Okay, so this is TORTS 101. The first part of this is it's a signal to all of you for whom this is going to be super repeat information. You can go refresh your coffee if you'd like. But basically we came up with this because we were experiencing more concerns and questions about kind of the collision between the judicial system and its pathway for addressing medical error and CRP programs. We thought it might be a good idea to just have a little webinar looking at the tort system and how it looks at medical error, and then look at CRP because there is kind of a collision of laws that apply to both, and it can be confusing and frustrating to look at how and when they intersect. So we came up with some learning objectives for the webinar. So first, we're hoping that when we're through, you'll be able to describe the basics of how the tort system operates in a medical error / adverse outcome situation. That you'll be able to describe the basics of how, when, and why CRP, apology laws, mandatory disclosure laws, and healthcare licensing systems intersect and/or collide with the tort system. And just as a quick aside, we're actually not going to get into any detail in the slides about licensing systems. I'll kind of mention them in passing because they're outside the tort system essentially, except for the connection between verdicts and licensing agencies in terms of when they open up an investigation based on a verdict or settlement. Third learning objective is for everybody, hopefully, to be able to identify 1 or 2 key points to assist you, depending on what your role is: quality, patient safety / risk, liability, covered carriers, patient advocates, and physician leaders. How do you navigate these intersections and collisions? I don't promise to have any answers for you, but okay, so now to the TORTS 101 portion. So let's look at a medical malpractice claim. So what is it exactly? So what is a professional negligence claim? So there's ordinary negligence and there's professional negligence, and they have different standards of care, and usually they're very similar in structure, but they're different in detail. So medical malpractice claim is a professional negligence claim. You can have one against not just a healthcare provider, but engineers and other professionals. So this is a particular type of professional negligence claim, and it's one filed against a healthcare provider generally. What that means is anyone who is licensed, certified, or registered as a healthcare provider under whatever state's law you're looking at. It's a civil lawsuit, that's as opposed to criminal. So it has a civil burden of proof. The criminal burden of proof is quite a bit higher in a civil case. This type of civil case, the plaintiff has to prove all the elements of their claim by a preponderance of the evidence. And that is often referred to as on a more likely than not basis. Have they carried their burden of proof? So what are the elements? Well, they're fairly standard across the country. There are 4 typical elements. Those are, in most states, those are found and interpreted in court opinions. So there aren't any statutes in most states setting forth the elements for med-mal claim. Washington is an exception. Washington has done what's called codified its elements in statutory law. So there is a whole section of the Revised Code of Washington that deals with medical malpractice. So that the elements themselves are in statutory law, that would still be interpreted by the courts, that law, if there were questions about it. So let's look at those. And these are Washington's elements. This is the example that I'm using because A, it is codified, and B, here we are in Washington. But again, these are fairly commonly the elements of a med-mal claim in any state. So the first element you have to establish is the plaintiff is that the defendant owed you a duty. That's an underlying principle of the Anglo-American system of law. It's a concept called there's no duty in the air. So that's a no duty to rescue basis for Anglo-American law. So you have to establish that the defendant owed you a duty. Well, in the healthcare setting, that's usually a given because you've got a patient-provider relationship. Sometimes you argue about whether that's been established, but not usually. So then we move on to element number 2, which is, did that healthcare provider breach their duty to you? And in establishing this element, generally you need an expert opinion in order to survive getting your case dismissed. There are rare exceptions, but usually you need an expert opinion to establish that the duty was breached. The third element is, it's kind of like, well, if the duty was breached, you're still not there if the patient was not damaged. So that's the third element. Again, generally you need expert opinion to establish that there is a damage, what the damage is. And then element number 4 is just connecting 2 and 3. In other words, if the healthcare provider breached their duty and the patient is damaged, but the damages that the patient has are not caused by the breach, then you're still not there. So that's another element where expert opinion is required with rare exceptions. So most of the time in the tort system, we're focusing on element number 2. Was there a breach of duty? This is usually called the standard of care question. This is the language that goes to a jury in Washington. This is part of the jury instructions because this is straight out of the statute. And the question for the jury or the other trier of fact, occasionally it's a judge, but did the healthcare provider fail to act, this is the way it's worded, as a reasonable and prudent practitioner in the class or profession to which he or she belongs, acting in like or similar circumstances? So reasonable and prudent is, well, what would that person do? And that's where the expert testimony comes in. In the class or profession which he or she belongs means that generally you have to have the same type of healthcare provider testifying about the type of healthcare provider who is the defendant. And acting in like or similar circumstances, what that's supposed to mean is that a jury is not supposed to put on what I call a retrospectoscope. They're supposed to consider everything from the perspective of the provider at that time and under the circumstances in which they found themselves. Kind of hard to do, right? Because everybody already knows what happened. So that's one of the problems with that. So how does the jury find out what the standard of care is supposed to be? This is the type of evidence that gets presented. Again, it generally all comes through expert testimony regarding current standards of practice. And so what you'll find is you'll have experts testifying about the standards of professional organizations, things like accreditation standards that set forth standards of care, that's Joint Commission, et cetera. Some journal articles, and then specific applicable policies and procedures from the institution, the healthcare facility, or wherever that healthcare provider is on staff. Those can all come in. And some of them are documents, but you still need the expert to basically testify about them. It's the way to get the documents back to the jury. So, because we're talking about the judicial system and we're talking about a trial, or at least a potential trial, here comes the concept of admissibility of evidence. So there are evidentiary standards, and these apply across the board to any civil trial. There are separate evidentiary standards for criminal trials. So it's important to remember that the evidentiary standards we are going to talk about now apply no matter whether you've had a CRP or not. So these are the evidentiary standards that govern with a with a tort law claim of medical malpractice. So the first one is an admission of liability or fault admissible? So if the defendant says, yes, I'm liable, yes, I'm at fault, is that admissible? So that the beginning position is yes, it's admissible if you can get through you can jump over other hoops that would otherwise preclude it being admissible. Those are things like, well, who said it? When did they say it? Does it meet a hearsay exception, et cetera, et cetera? But conceptually, it's admissible unless there is an evidentiary standard that says it's not admissible under these circumstances, and we're going to look at that. So it's important also to remember that we're talking about whether the defendant actually does admit liability or fault, not whether they could be required to admit liability or fault. And that's probably the most critical concept to think about in this light, in terms of when we look at the collision between the judicial system and kind of the CRP pathway, is because the tort system exists, even though if a defendant does admit liability or fault that may be admissible, that does not mean that the defendant is required in any way to admit liability or fault. In fact, the opposite is true. Because of our civil system, they cannot be required to admit liability or fault. Otherwise, it would make a big chunk of the tort system just useless. So anyway, we'll get back to that. There are other evidentiary standards that apply as to whether and when something called sympathetic gestures are admissible, are offers to settle admissible, are remedial measures admissible. And that's when you say, well, hey, this must have been negligence because they did all these other things afterwards to fix them. So we're going to look at those. So here's the segue. So what can you say and when can you say it in terms of whether or not that would be admissible in a tort claim later on? And the two big buckets for that are a bucket that's usually referred to as apology laws, and then some other disclosure protection laws. So you'll see it referenced in the literature as either a full apology law or a partial apology law. So again, this is Washington law. So here's Washington's law on a full apology. Yes, in the healthcare setting, so it's quite narrow in Washington, you can make a full apology within 30 days. And that is not admissible in court as an admission of liability, as long as it's made within 30 days. That is a new law, not so new anymore, right? But that was a change in Washington law as of 2006. So Washington is it's just a handful of states that have a full apology law. Washington is one of them. Partial apology laws are much more common. Washington has had a partial apology law for quite some time, still has that partial apology law. The difference between the full apology law and the partial apology law is that the full apology law applies only to healthcare providers and is only good for 30 days. The partial apology law applies to basically anybody who's at the wrong end of a negligence lawsuit, and it applies anytime. So what falls into this bucket? Anything you say about what you've done to try to prevent a recurrence, that's not admissible. Any sympathetic statement that you make, gee, I'm really sorry this happened, those are not admissible. They're not admissible to prove liability. In addition to the general evidence laws that affect individual healthcare providers, there are some special disclosure protection laws for facilities in Washington. So it's one hand gives and the other one gives if you comply. One hand requests you to do certain things and it gives you a carrot if you do that. So hospitals and ambulatory surgery centers are required to have, and under the licensing laws, are required to have policies to assure that if you do disclose, and saying you must disclose, information about unanticipated outcomes to patients, families, and surrogate decision makers, that's not admissible. So if you disclose an unanticipated outcome to a patient or their family, it's specifically noted in that law as not an acknowledgement or admission of liability. So just looking very generally and overall at other state laws. So this is how confusing it is. If you look at the literature on this, you'll find, and people categorize states differently. So somewhere between 32 and 34 states and the District of Columbia have partial apology laws, and somewhere between 5 and 7 states have full apology laws. That list of 5 to 7 states variably includes these 7: Arizona, Colorado, Connecticut, Georgia, South Carolina, Vermont, and Washington. But there have been a number of articles, and recent ones too, that don't put Washington on the full apology law list. And they never really say why. I think it may be because it's only 30 days. But you know, at least for that 30 days, Washington does in fact have a full apology law. So that's why this list is a little squishy. So moving on then, that was a quick trip through admissibility. There are, in addition, other ways that you can approach a med-mal claim that's in the judicial system. So you filed a complaint, basically, and it's moving along. So you can, sometimes a bifurcated trial is agreed to, and that's where the parties agree, well, let's try part 1. And if we have, that's on liability only, and because it's more involved to try the whole thing in one big chunk. So it's split into 2. And the first part is we're going to try it and see if there's a finding of liability. If there isn't, we're done. And if there is, then we can proceed to try the issue of damages in part 2. As part of the liability finding, there's the issue of allocation of fault among defendants, and this is typically true that there's more than one defendant. There's an institutional defendant and individual defendants, and so the jury is charged with allocating fault by percentages among the defendants. And then there's this concept of joint and several liability. If the plaintiff is faultless, that means that any single defendant can be holding the financial bag for the verdict for the other defendants. Now they have a right to seek recovery from the other defendants, but that's a concept of joints and several liability, which, you know, we could spend hours on. There's also the concept of contributory negligence, and that is when you don't have a faultless plaintiff. It usually is, if it's going to be argued, it's argued in the area of a patient who's non-compliant. Those have been not super successful, mostly based on the idea that the healthcare provider has superior knowledge and should do more to try to get the patient to comply. So, and there's a line somewhere, right? But that's what contributory negligence is. And again, the jury would assign a percentage of fault to the plaintiff. What that does is it will reduce the damages award. Another thing that you can do is something called a causation defense. So you say, okay, yeah, the standard of care was breached, but it didn't cause the plaintiff's damages. Those can be quite tricky to try, but you also can go one step further. You can say the standard of care was breached and that caused the plaintiff's damages, but we're going to argue about the extent of those damages, so let's try that piece only. So nice segue. What are the damages that are available? They fall into 3 general buckets. Special damages is things that you can itemize, right? Healthcare costs, lost income. General damages are just exactly what that sounds like. It's an amount of money that's attached to the patient's pain and suffering, emotional distress, etc. And punitive damages pop up, which can be quite costly, only if they're allowed under the specific state's law. And Washington does not allow them, so, but other states do. So that was a whirlwind trip through the tort system. We'll come back briefly after we look a little bit at what I call the extrajudicial medical error system. So that's how we handle medical errors that's outside of the court system. So, and that's done in a couple of basic primary ways. The first is state laws and other regulatory requirements to do mandatory adverse event reporting. A good example is the Joint Commission's sentinel event reporting. And here's their definition of a sentinel event. This used to be the only definition, this really short one. And then they tacked on a list of 15 specific types of events. Here are a few examples. You can definitely find the list in the appropriate accreditation manual for your organization. The Joint Commission does not require you to report sentinel events, but you must document investigation and review according to Joint Commission criteria, because they will be looking at that when they come to do your survey. So they do encourage it. Then there are state laws around mandatory adverse event reporting. So if you look at Washington, for example, Washington requires medical facilities, which are defined here as being in this bucket, confirming that a certain type of adverse event has occurred. It has to report to the Department of Health. And here are the time frames. And also, once you report an adverse event to DOH, you're required to conduct a root cause analysis. So what is an adverse event? Washington State used to have its own laundry list, but then several years ago, they moved to the National Quality Forum list, as it may be amended. It used to be 28, now it's 29 total serious reportable events. You can find that list at NQF. And once you report an adverse event through DOH, the individual reporting details that are covered by statutory QI privilege are not public, but the basic reporting fields are. So which facility, which event category, and the aggregate data are publicly available. And DOH has information about that on their site. So not to be confused with mandatory reporting of certain adverse events are laws and regulations that require disclosure of adverse events. And that is basically the million-dollar question. What does that mean? Common characteristics of these laws and regulations is that they will refer to very vague terms like unanticipated outcomes. There is no requirement in any of these to admit fault or disclose error because, well, you saw why. You can't be forced to admit something that is fodder for the tort system. So here's what the Joint Commission says about that. Patient safety standards require that hospitals provide the patient with information about outcomes of care, treatment, and services that the patient needs in order to participate in current and future healthcare decisions. Well, that sounds like informed consent, right? What this means is the Joint Commission has made disclosure of unanticipated outcomes part of informed consent, essentially. And here's their phrase about unanticipated outcomes. So here we are again, unanticipated outcomes of the patient's care, treatment, and services that are sentinel events. So they've limited it here, the scope, but they still call it unanticipated outcomes. And here's who has to provide it. Washington also, state law, requires hospitals to have policies in place to assure that this information is provided to patients or their families or any surrogate decision makers. Washington does not define unanticipated outcomes at all. in this section of the statutes. And that's the rub. When you look at these, if you find a definition, it's going to look like this stellar example. An unanticipated outcome is an outcome not anticipated in advance. So this is a very typical attempt to define unanticipated outcomes. Maybe not super helpful, but there are attempts to narrow this, like the Joint Commission has done, saying, well, something that's a sentinel event. And then they have other categories that they put other types of outcomes in, and they talk about how you're supposed to handle those. Yeah, so this is one of the problems, is how to define it. But the main point here is that none of these requirements require an admission of fault. So here are the list of states. There's a group of states that use the National Quality Forum serious reportable events like Washington does, and there they are. And then there are states that do mandate reporting of serious adverse events, but they have their own list. And here are those states. It's still not all that many states. So back to the tort system. So how does a tort system limit the extrajudicial system? Well, one way that we just talked about is that mandatory disclosure laws cannot require an admission of liability. So that basically the tort system trumps alternative dispute resolution unless the parties have agreed to binding arbitration as an alternative dispute resolution system. Law may not require an admission of liability. It's similar to an admission of guilt in the criminal context. You can't make somebody admit guilt. So you can't, in the civil system, you can't make somebody admit liability. Now, if they do, then you look at whether or not that's admissible or whether there is an evidentiary standard that keeps it out under certain circumstances. The law may encourage admissions of fault or liability within the extrajudicial context. But so this is a practical matter. If you're going to encourage this, you have to offer some protection from admissibility if the matter does move to the tort system. Otherwise, the feeling is that people are not going to be motivated to use those alternative pathways, which may or may not be a valid argument. And one of the reasons that that this is set up this way and has stayed this way is that attempts at tort reform have been kind of dismal. And so if you look at this state, there was a big tort reform attempt, a big package passed in 1986. 100% of it was trashed by the state Supreme Court. It was mostly the first Tort Reform Act was mostly around damages caps. They were all found to be unconstitutional. And why was that? Washington state constitution is particularly robust on plaintiffs' right to access a trial, particularly a trial by jury. And an attempt to monkey with what the jury could do was just found to be unconstitutional. So those caps were all struck down. And there have been some interim efforts to say, okay, well, let's try a little tiny tort reform. These were mostly in the 90s and early 2000s. So they tried a certificate of merit. What that meant was before you could proceed with a med mal case, you had to file a certificate of merit from a healthcare provider. You would think that would be pretty benign, but that got struck down as well. Another attempt was to limit / prevent tolling the statute of limitations for a claim by a minor, which was the age of majority, 18 plus their 3 years of discovery, 21. And so this attempt was to say, well, we're going to consider parental knowledge of the claim, the elements of the claim, to be imputed to the minor. So that clock's going to start ticking when the parent's knowledge trips the discovery of their claim. That also went by the wayside. So all the attempts in this state to do tort reform, particularly in the med-mal arena, have met, you know, unceremonious ends. So here's a question. Are apology laws the latest attempt at tort reform? So in a way, you could say yes, because it's an effort to modify the tort system to prevent certain things from being admissible in a trial, right? So are they going to suffer the same fate that earlier tort reform attempts did? So far, they appear to be surviving because it's been 14 years for our limited healthcare provider 30-day admission of fault, not admissible law. So the thought is, well, are these less likely to be struck down than previous attempts? And why is that? So I'm not going to answer that question right now. We'll see what you think. I'm not sure I have an answer. So what is the answer? If we can't do tort reform, if we can't chip away at tort reform, what can we do? Well, I suppose one thing you could do is what happened in the workers' comp arena, because you used to be able to sue your employer for negligence a very long time ago. Should it be wholesale replaced by a no-fault system for medical malpractice cases, similar to workers' comp? Well, here are some potential problems. No general damages are going to be allowed there, right? So is the state constitution going, is the Supreme Court going to say, no, that violates the state constitution? And they would primarily be looking at things like limiting damages. On the other hand, you know, the workers' comp system, you know, basically effectively replaced suing your employer for negligence. Now you can sue your employer, but it has to be an intentional injury. So, you know, my own opinion, which, you know, I will offer freely, and it's worth about that much, is that that would be the way to go, particularly because the tort system, I don't think is any longer a really good arena for the complexity of medical care that we have developed in the 20th and the beginning of the 21st century. So it feels to me like a workers' comp style system would work better. But, or here's our other option, right? Which is what we're doing. Continue to support and broaden laws that encourage CRP as an alternative dispute resolution pathway. Again, the problem is, well, here's the tort system over there like the elephant in the room. It remains available. So as a practical matter, laws that encourage CRP, you know, kind of intuitively, you would say they need to provide some incentives, such as non-admissibility. Even though apology laws may not significantly decrease med-mal claims. There's a huge article in Stanford Law Review from February 2019. I highly recommend reading through it. Although I will tell you that they are, this is one of the sources that did not put Washington on the list as having a full apology law. So take that with a grain of salt. But it's a very good article, and they do talk about, they kind of summarize the evidence and the research to date about the effect that apology laws have had on med-mal tort claims. And it does not appear to really be much, which kind of supports the idea that that CRP is independently useful, even if it doesn't, you know, do much in the tort claim arena. So they're kind of operating in parallel almost, except for the incentives that you want to offer to kind of try to drive people towards CRP instead of the tort system. So takeaways. Be interested to see what your takeaways would be. So here are mine after looking at this arena. You know, I would say it's frustrating and probably not too productive to focus on a goal of reducing claims frequency or severity. So that your goal for encouraging CRP, I think you're going to be frustrated if you say our goal is to reduce our claims frequency or severity, so we're going to do CRP. CRP is the right thing to do. It's patient-centered. It's consistent with a commitment to quality. It is the right thing to do. There are many reasons to try to avoid the tort system. Even though it may not reduce your visits to the tort system by frequency or severity when you get there, it's just, and I kind of mentioned this in passing when I was talking about why I think workers' comp is a better model. It's adversarial and punitive in nature, and it's very inconsistent with just culture principles. So you almost have to have 100% bad actor in the tort system. Well, it's not always that clear, right? So the tort system's a terrible place to try to deal with this because of the way that it's set up. So again, my feeling is that we should keep trying to support laws that will incentivize people to avoid the tort system and drive resolution to the CRP pathway. And one example is not being able to use admissions and apologies within a CRP. And right now, of course, the law is broader than that. You don't have to be in a CRP to have those non-admissibility pieces apply. But that is one of the incentives, not being able to use those outside the CRP pathway. So you can't then pick it up and transport it to the tort system. It's kind of an incentive to say, let's stay out of the tort system if we can. And you can't always. So questions?
So we've gotten some questions in the chat box, Cindy, so
okay.
I will just read those in the order that we've gotten them. So Tom asks about the no-fault system similar to workers' compensation. He says that's in place in a few countries for medical harm, New Zealand and Scandinavia. Any thoughts about how this approach has worked in those settings?
So I've only looked in general at information from those countries, and I've looked more closely at New Zealand. I think Australia has one too. And my impression is that it works quite well. And those have been in place for a while. And warts and all, in this country, the workers' compensation system does operate pretty well. So yeah, I mean, I think we have examples in other countries. Now, what you want to do is you want to look at. It's kind of an odd mix of, what do their constitutions look like? How sacred, I'll put that in quote, is their protection of the rights to a civil trial? That'll tell you how difficult it's going to be to try to get it replaced. But again, we did it in this country for workers' comp. Now, that was a while ago, but it also took a while to be successful. So yeah, I think we definitely have other countries we can look at, and my impression is that those systems work pretty well because patients get the help that they need, and I'm less familiar with how they are incorporating things like apologies into those systems.
Great. The next question is, do you think state laws in Massachusetts, Colorado, Iowa, and Oregon to support CRP have been helpful?
That's a great question. I think that if you read the Stanford Law Review article, I think defining helpful is very challenging. Helpful in reducing the frequency of claims or the severity of claims, probably not. That's what it's looking like anyway. But again, if you shift your focus to, well, what would helpful look like? Would it mean, higher patient and provider satisfaction with how adverse events are handled? Just intuitively, having been through, so I've been through both, right? I've seen these things unfold in the tort system. I've seen them unfold in kind of an alternative pathway like CRP. It's a whole lot, it feels a whole lot, it never feels good, right? But it feels a whole lot less awful outside the tort system. So it depends on how you define helpful, I think. But I think that the evidence that it's really reducing, you've got some anecdotal and some early studies. The first one that came out was the VA, but again, they're protected in part by the Federal Tort Claims Act. So it's kind of hard to analyze what those data look like in terms of reducing their claims frequency and severity. So yeah, I mean, I think anything that encourages people to use CRP, you know, quite frankly, I would look more at what do those numbers look like? And I'm not sure people are really counting those. Like, how much are we using CRP? Is the utilization going up? As opposed to looking at what's happening to our claims frequency and severity. That's pretty long-winded, but.
I'll also read a comment from Jean Martin. Our experience in Colorado with our Candor Act has shown that it really drives the use of CRP. Having worked out the law with the patient's attorneys as they did in Iowa has made this a pretty collegial process.
Yeah. Oh, that's great. That's great. Trying to remember whether they even mentioned that in this big Stanford Law Review article. By the way, if you look for this, you'll see people citing this Stanford Law Review article right and left. So yeah, I don't think that they mentioned that, but that would be what I would look at.
Great. Another question is, some have expressed concern that given the power imbalance between patients and healthcare organizations, patients trusting the CRP process could be taken advantage of. What safeguards are recommended to address this concern?
So from my perspective, I think that the best set of safeguards is to follow a standardized process and have your program set up the way, for example, the CAI's model program. You know, get your program. You know, well, we've looked at what would a law look like that would say, if your program meets these criteria and you get some kind of certification from your state agency, we've looked at that too and said, would that help? That way you could build in these safeguards, like requiring, for example, having patients and families be able to, and even affirmatively saying to them, do you want to bring your lawyer? Those kinds of things. I think that's how we address it. We have a set of standards that's been vetted and developed by an organization like CAI, and then if you're looking at trying to develop laws in states, you rely on those. But the complexity is in, so you're going to have to rely on those. You'll have to comply with those kinds of standards in order to reap the benefit. What does that look like? That's a little more complicated. I think it can be done, but people argue about that part all the time as well. Okay, what is DOH going to have to do? Are they going to have to certify people? And then what happens, right? Then you only get the non-admissibility if you've jumped through this set of hoops. Maybe that's what we do.
What do you think the most common misconception is about the relationship between CRP and the tort system?
I think the most common misconception is I would call it more confusion, which is kind of how we started. I think there's a lot of confusion about, well, why can't states mandate disclosure of error? I think that's a very, very common source of confusion. And so when people look at proposed candor type laws, they'll look at them and they'll say, yeah, but this doesn't mandate them to disclose the error. What good is this? It's a constant source of confusion. So that's, I think, what I would call the misconception. And again, it's the 800-pound gorilla in the room is the tort system.
Great. We've got a question from Kay. Does CRP prevent disclosure of the malpractice to the licensing boards or the public? If so, how can licensing boards identify physicians with problem malpractice records, and how can future patients be protected?
So that's a great question. Obviously, licensing agencies still need to fulfill their functions, and they have independent spheres in which they regulate that require certain notifications to be made to them. And then they have to decide how they're going to proceed with those. I think that when we've looked at this, we think it's critical to involve licensing agency functions if you're going to do a complete state law treatment of this. For example, and the Washington Medical Commission has been quite active in this arena. There's no reason why you can't encourage your licensing agencies to develop an alternative pathway for how they're going to look at things. If somebody has used a CRP process, that doesn't mean that they don't find out what's going on. And Washington Medical Commission has, in fact, looked at this, and they have proposed an alternative pathway that they will look at. That doesn't mean that they will not take appropriate action if they believe patient safety is at risk. So they will take appropriate licensing action. But what they are willing to hold off on is, well, we're not going to open a square one investigation into this if it's already been done under a certified CRP process. We're going to take that at face value, and then we're going to look at, what does this say to us? We don't have to investigate this ourselves, but we still have the authority, as they should, to limit or suspend or terminate a license based on their estimation that patient safety is at risk. So yeah, I think they have to be involved for sure, and to a lesser extent, hospital licensing agencies as well. Although that's less detailed than what individual licensing boards are faced with. So.
Cindy, this is Tom. This is really a wonderful presentation. Thank you so much. And I can just add a little bit on the relationship with the state licensing boards. You're exactly right. The Washington Medical Commission has been very active in this space, and Paulina can send around to the group, if you're interested, the memorandum of understanding that the Medical Commission developed with the Foundation for Healthcare Equality here in Washington State for a process that's called CRP certification. You're describing a little bit more of what we're expecting the future state to look like in terms of the Medical Commission potentially holding off on investigations if a CRP process is being used. The current state really is, we're in something of, I would describe as a pilot phase where, so the CRP certification process, it's a group of independent reviewers at the Foundation for Healthcare Quality, which is a not-for-profit quality and safety entity in Washington. And interested organizations who have used the CRP for a case can fill out a detailed application describing exactly how they did this, and the review panel reviews the case and offers the organization feedback on what went well and opportunities for improvement, and makes a decision about whether it met the standards for what a CRP should look like in an individual case. And that certification goes back to the applicant organization, and they can choose whether or not to submit that certification report onto the Medical Commission. We've had, I don't have the exact number right off the top of my head, at least in the mid-20s of cases go through this process. Interestingly, many more organizations are using the process to get feedback from this neutral group about how could I do a better job with my CRP. Some are choosing to send the certification report on to the medical condition. And in all of those cases, the medical commission has closed the case as satisfactorily resolved without disciplining the providers, which is great. But the medical commission does, as Cindy said, maintain all of its authority to investigate, to discipline that they normally would. But the reason that it's so helpful is that in Washington state, lots of physicians were concerned that by engaging in the CRP process, especially if a claim was going to be paid, it increased the chances of a report to the medical board, and they worried that the last thing they wanted to do was draw any attention to themselves by the medical board, and worried that they might be disciplined. So this process helps reassure physicians that participating in the CRP process, if anything, helps them when it comes to involvement of the medical commission. And we've been doing great work with Beta, the Beta Healthcare Group, on extending this process into California, although in California it really focuses on the feedback to organizations. We've not yet engaged the Board of Medicine in California. But for those of you who are interested in what it looks like when a medical board or commission really digs into just culture and CRP, have a look at that memorandum of understanding, because I think it's a nice example of how to work together with regulators on this topic.
Yeah, they did a really good job on that, I think. And then the other thing, Tom, I don't know if you've talked about this, but at some point you may want to approach the FSMB, which is the Federation of State Medical Boards, and see if you can chat with them. For example, SFMB did a model telemedicine policy for medical boards, so they might be interested in looking at this as well.
Yeah, we have been in conversation with FSMB, not recently, but you're right that now that there's more accumulated experience, it might be a good time to do that. And it's really just another piece of sort of encouragement or incentives for providers and organizations that using this approach will benefit you, not hurt you. And I think all of that really adds up and encourages organizations to try to use these principles more consistently.
Exactly.
Great. I think the last question I saw was, are you aware of any national efforts to standardize CRP programs and laws?
So I think that national efforts would come mostly from organizations like FSMB, so policy organizations, Federation for Healthcare Quality, organizations at that level. It's very tricky to try to address this from a regulatory perspective at the federal level, because states are in complete control of their healthcare provider licensing laws and their individual tort systems. So nothing at the federal level could affect a state's tort system, if that makes any sense. If you, they can, their attempts to create kind of a quasi-national QI privilege with PSOs has been marginally not so successful, because again, that's an area that's left to states to regulate. But I think that national organizations and policy groups definitely, could be quite active in this arena, doing things like model laws, uniform laws, national types of policies like FSMD does, for example.
And Cindy, Tom, I would just add that, organizations like the Collaborative, like Macrame in Massachusetts, and individual groups, insurers like Beta, I think there's clear consensus now on what the best practices look like. What are the key elements of a communication and resolution program? There are some modifications that need to be made for non-employed physicians, but we're making good headway working with insurers. Beta hosts essentially an alliance of insurers thinking through how they partner with one another when there are CRP cases. So even though it's a little hard to imagine sort of national CRP requirements quite yet, there is a lot of consensus around what best practices look like.
Right. Yeah, I really think you're not going to be able to see anything in actual regulatory law that's going to apply across the board, but what you can work toward is a national consensus. And it sounds like the most important place is thing to agree on is what are the best practices, because that's going to drive what each state is going to do. So
thank you all for joining, and thank you very much, Cindy, for this great presentation. The recording and the slides will be available on our website, hopefully by next week. And thank you all for attending.
thanks for having me.